Before I formally open this hearing, I would like to say a few words since this is the first time I'm speaking publicly in my role as Commissioner of the Commission of Inquiry into Money Laundering in British Columbia. As Mr. Martland and Mr. McGowan mentioned, this hearing has been convened in accordance with a direction I made following the receipt of 20 applications from various individuals and entities seeking leave to participate in the Commission of Inquiry into Money Laundering in British Columbia. On September 24th of 2019, I granted participant status to 16 of the applicants with a direction that the remaining 4 applicants, Messrs. Alderson, Damaris, Lightbody, and Pinnock, attend an oral hearing of the inquiry to enable a further review and determination of their individual circumstances in light of the relevant considerations governing these applications. In the meantime, the British Columbia Real Estate Association sought an extension of time to apply for participant status. I granted that extension of time, and in light of their application, I granted their application for participant status on October 15th of 2019. My reasons for doing so are posted on the Commission's website. As you've heard, and as it transpired, Mr. Alderson, after discussions with Senior Commission Counsel, has elected to withdraw his application for participant status, being satisfied that if he is called as a witness, he will be able to contribute to the work of the Commission to the extent that he wishes. Before considering the remaining 3 applications, it seems appropriate to provide a brief overview of the nature and the scope of our mandate and to say something about the Commission itself, which will help to give some context to the remaining applications. As I noted in the introductory statement, which is posted on the Commission's website, there appears to be a consensus among law enforcement officials, academics, and subject matter experts that British Columbia is a jurisdiction in which money laundering is flourishing. The mandate of the Commission, which was established by the provincial government, is very broad. It encompasses various economic sectors where money laundering is said to have taken root, grown, and evolved, and it requires the Commission to make findings of fact in relation to a number of things, including the extent, growth, evolution, and methods of money laundering in British Columbia with regard to specific economic sectors, the acts or omissions of responsible regulatory agencies and individuals, and whether those have contributed to money laundering in the province or amount to corruption. The scope and effectiveness of the anti-money laundering powers, duties, and functions of these regulatory agencies and individuals, and the barriers to effective law enforcement in relation to money laundering. In addition, the Commission has a responsibility to make recommendations to address the conditions that have enabled money laundering to grow and evolve in the province. In recent years, there has been extensive media investigation and coverage of money laundering. There have also been studies and reports prepared by academics and other experts that shed light on the prevalence of money laundering in the province and its noticeable effects. As a result, the public has become aware of and concerned about this problem. One recent poll reported that approximately 90% of British Columbians are concerned about money laundering. It is part of this inquiry's role to add to the public's understanding of the nature and scale of money laundering in the province and to address its concerns to the extent possible through recommendations for action. There's also an incidental benefit from simply bringing additional concentrated attention to the crime of money laundering. The more awareness there is of its presence and of the profound social harms it springs from and propagates, the less complacency there can be for facilitating or tolerating it. Brock Martland, QC, and Patrick McGowan, who are present at this hearing, are the two senior commission counsel. They have undertaken the significant responsibility of assembling and organizing the evidence that will be placed before the commission at the hearing stage. The evidence will come from many sources and will cover a broad array of topics. To assist in this task, they have put together a very capable team of lawyers and consultants. Biographies of all the commission counsel are posted on our website. This commission, like all commissions appointed under the Public Inquiry Act, is independent of government. We serve the people of British Columbia. This means that the commission must live up to certain standards in conducting its public hearings. One of the integral standards is that of fairness to those whose privacy interests, legal interests, or reputational interests may be affected by the proceedings. Another important standard for the commission is thoroughness. The commission must do its utmost to ensure that its subject matter is comprehensively and meaningfully covered. That entails hearing from a range of voices and points of view. One of the mechanisms of ensuring fairness and thoroughness is permitting certain parties to act as participants in the proceedings, if their interests may be affected by the findings of the commission, if their participation would further the conduct of the inquiry, and or if their participation would contribute to the fairness of the inquiry. Not all persons or organizations' representatives who may be called as witnesses are entitled to participant status. If a person believes that he or she has relevant evidence to give, they may be entitled to testify and they may be represented by counsel. It does not follow that having relevant evidence to give justifies a grant of participant status. The other conditions I have mentioned must be in play. This hearing is not adversarial. It's an attempt by all present to get at the root of the question of whether Messrs. Damaris, Lightbody, and Pinnock meet the criteria for status as participants, or whether their involvement is appropriately confined to that of a witness or potential witness. I do not anticipate any need for extensive evidence or any cross-examination at this hearing. A simple exploration of the factual and statutory conditions at issue will lead to an appropriate resolution. As I understand it, Mr. Martland and Mr. McGowan have spoken with counsel for Messrs. Damaris, Lightbody, and Pinnock and have agreed upon a format for proceeding this morning. I will shortly ask one of them to set forth what format those proceedings will follow, but in the meantime, we'll stand down briefly to permit the cameras to be cleared from the hearing room. Right.